Yes, sir.
All rise, the Honorable Judges Chief Caden, Justin, and Jabarius are entering the courtroom. All rise. Please be seated. SeaWorld attorneys, are you ready to begin your opening remarks?
Yes. Yes, Your Honor. Good morning, if please the court. I am Darian Smith representing the petitioner. SeaWorld, in this case, I would like to reserve 5 minutes for review time. SeaWorld is a widely admired steward of marine sea life that the court below found to be a safety, cautious employer that set the standards for its industry based on its expertise and experience. SeaWorld believes that the protocols it has put in place controls the hazard that undeniably can be presented by killer whales. These facts demand judgment by SeaWorld under the general duty clause, as it has historically been applied by the courts.
What about the agency's position that the protocols place the obligation not on the employer but on the employee?
Your Honor, I think the industry agrees that full safety depends upon employees understanding the rules and representing approximately under certain circumstances. Therefore, throughout OSHA law, you see great emphasis placed upon training. The training program at SeaWorld has been a widely admired program. OSHA has admitted that they are not questioning SeaWorld's training program, but it has not only SeaWorld's training programs that ensure the safety program. SeaWorld includes as well as series of emergency measures that they were prepared to take, as well as the training of the whales themselves.
Is it your position that we're an employer and substandards the agency under the general duty clauses no role to play?
I wouldn't say no role to play, but 2 points on your comment first. The judge here improperly applied a 100% safety test, which is inconsistent with this court's decision in prior cases. But as to OSHA's role, the other thing that is extraordinary about this case is 2020 hindsight engaged by the government and its reliance on an unqualified government expert to do something that no court has ever done before, which is to tell a company that it cannot continue to offer the product that had exists to offer to the public. It's like the federal government had come in and told the NFL that close contact on the football field would have to end because more people are injured in the NFL on any given Sunday.
Judge Lee?
No, he's not finished. Then we're injured in 22 period that OSHA looked at is you have to wear helmets. What if this was before 1943 when the NFL did not require helmets? Would that change the nature of your NFL presentation?
I think that this gushable question. Distinguishable. Yeah, distinguishable, whatever that word is, question.
Wouldn't this be the same, like asking, I don't know, NASCAR to reduce speed limits? What if the OSHA says was that you have to wear seatbelts? What if this was in a period before seatbelts? I remember a time when hockey goals didn't wear masks, goalies didn't wear masks, but everyone wore masks now. Wears masks now.
There is a fundamental difference. What the judge did here was characterized as a stark change in the company's business model. Premise the business's model of SeaWorld is to offer close contact between whale and human. If close contact in the NFL were eliminated by OSHA, there is no doubt that would be an improper implementation of the general duty clause. If I may address the experts, whatever issue and what role there might be for OSHA, the agency expert in this case was highly unqualified to render opinions in the manner that he did. He teaches in the geography department. His expertise is on the behavior of whales in the wild. How could he properly render input of hazards at a marine park? How could he properly render methods? Consider the concessions that he made. He said that he did not know if whales' behavior changed in captivity. Imagine that how could someone who only observes mammals in the wild understand how to manage them in the zoo? He says, I don't know if captivity changes their behavior.
How do you address the fact that the judge noted that SeaWorld had changed its presentation after the change was done?
It did, Your Honor. SeaWorld has a history of continually in examining what has happened in the past and improving its safety processes. If you look at the 2-year period that OSHA looked at, in this case, SeaWorld reduced the innocent to 1/3. It is interesting to note that the lower court is stating that the practices that SeaWorld usually are legal, that there should be no close contact. SeaWorld's position is that the close contact is its business model. SeaWorld's position is that the close contact is necessary for the care of its whales.
As they understand this, SeaWorld has admitted to keeping records and that this particular whale had a history of aggressive actions. The lower judge was just merely recommending that there be some sort of areas separated the whale.
Judge, that is simply not true. OSHA brought a new case against us. OSHA lawyers got no more than 2 sentences into their statement before they said that close contact with whales must be ended. We currently no longer have waterworks, but we
we do still use dry work with the wells, just not the well in question. I wish to come back to our expertise. If you look at past cases, we reverse decisions because of the lack of property expertise. In this case, OSHA's expertise falls far behind as compared to SeaWorld's expertise. It's like bringing a bird watcher in to tell a zoo how to run it. There could have been experts called in from a zoo and another theme park, somebody who actually knows about the care and training of animals. In this case, the well in question had a history and lives that is why SeaWorld very needs and water work here for the well had never harmed any SeaWorld employee in its 18 years with SeaWorld.
Prior cases have stated that you can't use the general duty clause to change the business model of the business of the model of a business. How do we draw the line here between the insurance model and something that is just a safety improvement?
You must look at what the company does. SeaWorld exists to offer the opportunity to view close interaction between whales and people. You should use the general duty clause to look at how a company operates and not what that company exists to offer.
Are the cases where people come to see an event where there are inherent risk?
Yes, I think that's true.
Surely you are not arguing that people should be able to attend events to see if the person is going to be killed?
No, SeaWorld is just offering an interaction between people and whales.
Is OSHA's attorney ready to present?
Yes, thank you, Your Honor. Charlie, what city must see? A recognized standard existed and a principal means of obtainment existed by substantiable evidence. I wish to start addressing the principal means of obtainment issue and identify what SeaWorld had already started eliminating. Obtainment means eliminating or materially using as
Oh, can you address the issue of previous case law that states some activities are inherently dangerous? That seems to entrench in the law that some business activities are outside the four factors of the general duty clause. OSHA can't change the insurance. I don't know. That nature of a product when it is doing its regulation.
Yes, Your Honor. Previous case law suggests that the hazard must be preventable. Preventably is the core issue.
But you can always prevent it by shutting down the activity.
The general duty clause does not allow shutting down the entire industry, but the situation is not present at all in the case. SeaWorld is nowhere near being put out of business. They are respectful and shows with no.
If they were losing business, would you say we have exceeded our authority?
Now, the feasibility test is the general duty clause does not contain an element of technology, feasibility, and economic feasibility. SeaWorld already weighed the economic feasibility argument at the proceedings below. SeaWorld has not argued to this case that the procedures are economically unfeasible.
So you concede that OSHA could not tell the NFL to ban tackle football?
We agree with that.
How do you distinguish the two?
SeaWorld's activities are not inherent to its business model.
SeaWorld said it was a central premise to its business model.
Close contact is the point of issue. Close contact can mean different things. The hazard in this case is the risk of traders being bitten or killed whales by working in close contact. That is the close contact activity that is dangerous. SeaWorld itself limited those activities after the trainer was killed. They have created and performed shows since then.
No, I don't think the fact that they have voluntarily changed practice is relevant. Wait, alright. To the question, you would be making the same argument if they hadn't changed.
I think SeaWorld's actions should show that the trial judge did not force them to change and show that there are ways to materially reduce the hazard that SeaWorld is capable of doing. We cannot believe the trial's court action would not put SeaWorld out of business.
Let's go back to OSHA's excursion.
An expert is a professor who has studied whales in a lot. Secondly, OSHA's determination did not rely upon the expert's testimony to render its decision. SeaWorld has experts, but they cannot be allowed to control their own public safety determinations based solely on this factor.
On the issue, it seemed unlikely that Congress will have intended for the general duty clause to control the nature of business models.
The purpose of general clause duty was to cover industries that typically didn't have rules in place. Just because the case is unique does not mean SeaWorld is exempt from the clause. This is something SeaWorld could have done to control the risk.
Is SeaWorld ready to review?
Yes, thank you, Your Honor. OSHA brought the wrong expert witness to this case. OSHA consult misspoke when she said the trial judge did not rely on this expert. The court transcripts show otherwise as to both presence of risk of visibility of adaptment. That is a simple basis to dismiss this case. They brought the wrong expert to this dance. SeaWorld has implemented intensive safety measures to date. It was the close contact between trainers and the whales that has provided from reduction in safety mishaps at SeaWorld. Yet it is that close contact that OSHA wants to end. SeaWorld continues to employ close contact as part of its business's model and safety reduction efforts is just plain wrong to use SeaWorld's own voluntary safety producers against it to show in their inherent dangers. Evidence SeaWorld reserves the right to alter its safety controls measures as the conditions change as for notice. OSHA is telling you that what safety measures SeaWorld is doing today is evidence of wrongdoing, and yet OSHA is trying to pursue SeaWorld for implementing those very safety measures. This case should defer to the real food experts and the industry's standards for recognizing inherent dangers. Otherwise, we are left at the mercy of USHA's neighborly rooms for execution. We contend that OSHA is not empowered under the terms of the general duty clause to change the environment business's model of investment.
Thank you for your testimony. We respectfully deny the penetrator's review.
All rise.
All rise. The Honorable Judges Ariana, Alexis, and Xavier are entering the courtroom.
SeaWorld attorneys, are you ready to begin your opening remarks?
Yes, Your Honor. Good morning, if it pleases the court. I'm Nicholas Campbell, representing the petitioner, SeaWorld, in this case. I would like to reserve 5 minutes of usual time. SeaWorld is a widely admired steward of marine sea life that the court below found to be a safety-conscious employer that set the standards for its industry. Based on its foresight and experience, SeaWorld believed that the protocols it had put in its place controlled the hazard that undeniably can be presented by killer whales. These facts demanded judgment by SeaWorld under the General Duty Clause as it historically been applied by the courts.
What about the agency's position that the protocols place the obligations not on the employer but on the employee?
Your Honor, I think the industry agrees that full safety depends upon employers understanding the rule and responding appropriately under certain circumstances. Therefore, throughout OSHA law, you see great emphasis placed upon training. The training program at SeaWorld has been a widely admired program. OSHA has admitted that they are not questioning SeaWorld's training program. But it was not only SeaWorld's training programs that ensured the safety program. SeaWorld included as well a series of emergency measures that they were prepared to take, as well as the training of the whales themselves.
Is it your position that an employer accepts standards the agency under the General Duty Clause has no role to play?
I wouldn't say no role to play, but 2 points on your comments first. The judge here improperly applied a 100% safety test, which is inconsistent with this court's decisions in prior cases. But as to OSHA's rule, another thing that is extraordinary about this case is that 2020 hindsight engaged by the government and its reliance on an unqualified government expert to do something that no court has ever done before, which is to tell a company that it cannot continue to offer the product that had existed to offer to the public. It's like the federal government had come in and told the NFL that close contact on the football field would have to end because more people are injured in the NFL on any given Sunday. They were injured in the 22-year period that OSHA looked at in this case.
Wouldn't these be the same as asking the NASCAR to reduce the speed limits? What if OSHA said what if they said that you had to wear a helmet? What if this was before 1934 when NFL did not require helmets? Would you change the nature of your NFL presentation?
I think that is a distinguishable question.
Yeah. Wouldn't this be the same as asking a NASCAR to reduce the speed limits? What if OSHA said that you had to wear seatbelts? What if this was a period before seatbelts? I remember the time when hockey people didn't wear masks, but everyone wears masks now.
There's a fundamental difference. What the judge did here was characterized as a stark change in the company's business model per month. The business model of SeaWorld is to offer close contact between whale and human. Close contacts in the NFL were eliminated by OSHA. There's no doubt that would be an improper implementation of the general duty clause. If I may address the expertise issue and what role there might be for OSHA, the agency expert in this case was highly unqualified to render opinions in the manner that he did. Teaches in the geography department, his expertise is on behavior of whales in the wild. How could he properly render input of hazards at a marine park? How could he properly render Benjamin methods? Consider the cautions that he made. He said that he did not know if whales' behaviors changed in captivity. Imagine that. How could someone who only observed mammals in the wild understand how to manage them in a zoo? He says, I don't know if captivity changes behavior.
How do you address the fact that the judge noted that SeaWorld in fact changed its presentation after the training session?
It did, Your Honor. SeaWorld has a history of continually examining what has happened in the past and improving its safety process. If you look at the 22-year period that OSHA looked at in this case, SeaWorld reduced the incidents to 1/3. It is interesting to note that the lower court is stating that the practices that SeaWorld is using are illegal, that there should be no close contact. SeaWorld's position is that close contact is its business model. SeaWorld's position is that the close contact is necessary for the care of its whales.
As I understand, SeaWorld has admitted to keeping records and that this particular whale had a history of aggressive incidents. The lower judge was just merely recommending that there would be some sort of barrier separating the whale from the trainer.
Judge, that is simply not true. OSHA brought a new case against us. OSHA lawyers got no more than 2 sentences in their statement before they said that close contact with whales must be ended. We currently no longer have water work, but we still do use dry work with the whales, just not the whale in question. I wish to come back to the R of expertise. If you look at past cases, reverse decisions because of the lack of proper expertise. In this case, OSHA's expertise falls far behind as compared to SeaWorld's expertise. It's like bringing a bird watcher in to tell a zoo how to run its behavior. There could have been experts called in from a zoo or another theme park, somebody who actually knows about the care and training of animals. In this case, the whale in question had a history in the wild. That is why SeaWorld barred any water work with the whale. The whale had never harmed any SeaWorld employee in its 18 years with SeaWorld.
Prior cases stated that you can't use the general duty clause to change the business model of a business. How do we draw the line here between industry model and something that is just a safety issue?
You must look at what the company does. SeaWorld exists to offer the opportunity to view close interaction between the whales and people. You should use the general duty clause to look at how a company operates and not what the company exists for.
Are the cases where people come to see an event where there are inherent risks?
Yes, I think that's true.
Surely you're not arguing that people should be able to attend events to see if the person is not going to get killed?
No, SeaWorld is just offering an interaction between people and whales.
Is OSHA attorney ready to present?
Yes, thank you, Your Honor. The trial court's duty was to see if a recognized hazard existed and a feasible means of abatement existed by substantial evidence. I wish to start addressing feasible means of abatement issue and identify what SeaWorld already had started implementing. Abatement means eliminating or materially reducing the hazard.
Can you address the issue of previous case law that states some activities are inherently dangerous? That seems to enrich the law that some business activities are outside the full factors of general duty clause. OSHA can't change the inherent industry nature of the product when it's doing its regulation.
Yes, Your Honor. Previous case law suggests that the hazard must be preventable. Preventability is the core issue.
Well, can't you always prevent it by shutting down that activity?
The general duty clause does not allow shutting down the entire industry, but that situation is not present all in this case. SeaWorld is nowhere near being out of business. They are still performing shows with killer whales.
So, right there. If they were losing business, would you say that we would have exceeded our opportunity?
No, the feasibility test of the general duty clause does not contain an element of technologically feasibility and economic feasibility. SeaWorld already waived the economic feasibility argument at the proceedings below. SeaWorld has not argued to this court that the abatement procedures are economically unfeasible.
So you conclude that OSHA should not tell them to ban technology?
We agree with that.
How do you distinguish the two?
SeaWorld's activities are not inherent to its business model.
SeaWorld said that it was a central premise to its business model.
Close contact is the point of the issue. Close contact can mean different things. The hazard in this case is the risk of trainers being bitten or killed. The killer whales by working in close contact. That is the close contact activity that is dangerous. SeaWorld itself eliminated those activities after the trainer was killed. They have created and performed shows since then.
I don't think the fact that they have voluntarily changed practices is relevant to the question. Would you be making the same argument if it hadn't changed?
I think SeaWorld's actions show that the trial judge did not force them to change, and that there are ways to materially reduce a hazard that SeaWorld is capable of doing. We do not believe that the trial court's action would not put SeaWorld out of business.
Let's go back to OSHA's expert issue.
The expert is a professor who has studied whales in the wild. Secondly, OSHA's determination did not rely upon the expert's testimony to render its decision. SeaWorld has experts, but they cannot be allowed to control their own public safety determinations based solely on this factor.
On the industry issue, it seems unlikely that Congress would have intended the general duty clause to control the industry nature of a business model.
The purpose of the general duty clause was to cover industries that typically didn't have rules in place. Just because this case is unique doesn't mean SeaWorld is exempt from the clause. There's something that SeaWorld could have done to control risk.
Is SeaWorld ready to rebut?
Yes, Your Honor. OSHA brought the wrong expert witness to this case. OSHA counsel misspoke when she said the trial judge did not rely on this expert. The court transcripts show otherwise as to both presence of risk and feasibility of abatement. That is a simple basis to dismiss this case. They brought the wrong expert to this dance. SeaWorld has implemented extensive safety measures to date. There was a close contact between trainers and the whales provided for reduction in safety mishaps at SeaWorld. Yet, it is that close contact that OSHA wants to end. SeaWorld continues to employ close contact as part of its business model and safety mishap reduction efforts. It is just plain wrong to use SeaWorld's own voluntary safety procedures against it to show inherent dangerous evidence. SeaWorld reserves the right to alter its safety control measures as the mitigation conditions change. As for notice, OSHA is telling you what safety measures SeaWorld is doing today is evidence of wrongdoing, and yet OSHA is trying to prosecute SeaWorld for implementing those very safety measures. This case should defer to the real field experts and industry standards for recognizing inherent dangers. Otherwise, we are left at the mercy of OSHA's daily moves for prosecution. We contend that OSHA is not empowered under the terms of the General Duty Clause to change the inherent business model of the industry. Thank you.
Thank you for your testimony. We respectfully deny the petitioner's briefing.
All rise.
Right up.
All rise, the honorable judges, Chief Brill, Amy, and Jolene, and Shannon.
You may be seated. SeaWorld attorney, are you ready to begin your opening remarks?
Yes, Your Honor.
Good morning. If it please the court, I am Anthony, representing the petitioner SeaWorld in this case. I would like to reserve 5 minutes for rebuttal time. SeaWorld is a widely admired steward of marine sea life that the court below found to be a safety-conscious employer that set the standards for its industry. Based on its expertise and experience, SeaWorld believes that the protocols it had been put in place control the hazard that undeniably can be presented by killer whales. This fact demands judgment by SeaWorld under the General Duty Clause as it has historically been applied to the courts.
What about the agency's position that the protocol places the obligation not on the employer but on the employee?
Your Honor, I think the industry agrees that full safety depends upon employees understanding the rules and responding appropriately under certain circumstances. Therefore, throughout OSHA law, you see great emphasis placed upon training. The training program at SeaWorld has been a widely admired program. OSHA has admitted that they are not questioning SeaWorld's training program. But it was not only SeaWorld's training program that ensured the safety program. SeaWorld included as well as a series of emergency measures that they were prepared to take, as well as the training of the whales themselves.
Is it your position that we're employee substantial agency under the General Duty Clause has no role to play?
I won't say no role to play, but 2 points on your comments first. The judge here improperly applied a 100% safety test, which is inconsistent with this court's decision in prior cases. That as to OSHA's rule, the other thing that is extraordinary about this case is that 2020 hindsight engaged by the government in its reliance on an unqualified government expert to do something that no court has ever done before, which is to tell a company that it cannot continue to offer a product that had existed to offer in the public. It's like the federal government had come in and told the NFL that close contact on the football field would have to end because more people are injured in the NFL on any given Sunday then were entered in the 20-year period that OSHA looked at in this case.
What if what they said was you have to wear a helmet? What if this was before 1943 when the NFL did not require helmets? Would that change the natural nature of your NFL position?
I think that distinguishable question.
Would this be the same thing, like asking NASCAR to reduce speed limits? What if what OSHA said was that you had to wear a seatbelt? What if this wasn't a period before seatbelts? I remember a time when lockdown police didn't wear helmet masks, but everyone wears them.
There is a fundamental difference. What the judge did here was characterized as a stark change in the company's business model premise. The business model of SeaWorld to offer close contact between whale and human. If close contact in the NFL were eliminated by OSHA, there no doubt would be an improper implementation of the government duty clause. It may address the expertise issue and what role there might be for OSHA. The agency's expert in this case was highly unqualified to render opinions in the manner that he did. He teaches in the geography department. His expertise is on the behavior of whales in the wild. How can you properly render input of hazards at a marine park? How can you properly render abatement methods? Consider the concessions that he made. He said that he did not know if whales' behavior changed in captivity. Imagine that. How can someone who only observes mammals in the wild understand how to manage them in a zoo? He says, I don't know if captivity changes their behavior.
How do you address the fact that the judge mentioned SeaWorld had in fact changed its presentation after it came back?
It did, Your Honor. SeaWorld has a history of continually examining what has happened in the past and improving its safety processes. If you look at the 20-year period that OSHA looked at in this case, SeaWorld reduced the incidents to 1/3. It's interesting to note that the lower court is stating that the practices that SeaWorld is using are illegal, that there should be no close contact. SeaWorld's position is that close contact is its business model. SeaWorld's position is that the close contact is necessary for the care of its whales.
As I understand it, SeaWorld has admitted to keeping records and has discontinued well as a history of aggressive incidents. The lower judge was just merely recommending that there would be some sort of barrier separating the law from traders.
Judge, that is simply not true. OSHA brought a new case against us. OSHA lawyers got no more than 2 sentences into their statement before they said that close contact with whales must be ended. We currently no longer have water work but we do still strive work with the whales, just not the whale in question. I wish I had come back to the area expertise. If you look at past cases, reverse decisions because of lack of proper expertise in this case. OSHA's expertise fails far behind as compared to SeaWorld's expertise. It's like bringing a bird watcher in to tell a zoo how to run its aviary. There could have been experts called in from a zoo or another theme park, someone who actually knows about the care and training of animals. In this case, the whale in question had history in the wild. That's why SeaWorld spared any water work with the whale. The whale had never harmed any SeaWorld employees in its 18 years with SeaWorld.
Prior case have stated that you can't use the general duty clause to change the business model of business. How do we draw the line here between the business model and something that is just a safety?
We must look at what the company does. SeaWorld exists to offer the opportunity to view close interaction between whales and people. You should use the general duty clause to look at how many how a company operates and not what the company exists to offer.
Are the cases where people come to see an event where there are engineers?
Yes, I think that's true.
Surely you're not arguing that people should be able to attend events to see if the person is going to get killed?
Wait. No, SeaWorld is just offering the interaction between people and whales.
Is OSHA's attorney ready to present?
Yes, thank you, Your Honor.
Trial court duty was to see if a recognized hazard existed and the visible means of abatement existed by substantive evidence. I was just addressing the feasible means of the issue and identify what SeaWorld had already started implementing eliminating or materially reducing the hazard.
Can you address the issue of these clause law? Well, that states some activities are inherently dangerous. That seems to in the law that some business activities are outside the four factors of the general duty clause. OSHA can't change the nature of a product when it is doing
Yes, Your Honor. A previous case law suggests that the hazard must be preventable. Preventability is the core issue.
But you can always prevent it by shutting down.
The general duty clause does not allow shutting down an entire industry. But that situation is not present at all in this case. SeaWorld is nowhere near being put out of business. They are still performing shows with killer whales.
If they were losing business, would you say we have exceeded our authority?
No, the feasibility test in the general duty clause does contain an element of feasibility and feasibility. SeaWorld already waived the economic feasibility argument at the proceedings below. SeaWorld has not argued to this court that admit procedures are economic unreasonable.
So you concede that OSHA could not tell the NFL to ban tackle football?
We agree with that.
How do you distinguish the two?
SeaWorld's activities are not inherent to its business model.
SeaWorld said it was essential to its business model.
Close contact is the point of issue. Close contact is going to mean different things. The hazard in this case is the risk of trainers getting bitten or killer whales by working in close contact. That is the close contact activity that is dangerous. SeaWorld itself eliminated those activities after the trainer was killed. They have created and performed shows instead.
I don't think the fact that they have voluntary change practices is violent to the question. You would be making the same argument if they had changed.
I think SeaWorld's action shows that the trial judge did not force them to change, and also that there are ways to materially reduce the hazard that SeaWorld is capable of doing. We cannot believe the trial court's actions would not put SeaWorld out of business.
Let's go back to the OSHA expert issues.
The expert is a professor who has studied whales in the wild. Secondly, OSHA's determination did not rely upon the expert's testament to render its decision. SeaWorld had met experts, but they would not be allowed to control their own public safety determination based solely on this factor.
On the issue, it seems unlikely that Congress would have intended for the general duty clause to control the nature of business models.
The purpose of general duty clause was to cover industries that typically didn't have rules in place. Just because the case is unique doesn't mean SeaWorld is exempt from the clause. There is something SeaWorld could have done to control the risk.
Is SeaWorld ready to review?
Yes, thank you, Your Honor. OSHA brought the wrong expert witness into this case. OSHA counsel misspoke when she said that the trial judge should not rely on this expert. The court transcripts show otherwise, as both presence of risk and vulnerability or of abatement. This is a simple basis to dismiss this case. They brought the wrong expert to this dance. SeaWorld has implemented extensive safety measures today. It was a close contact between trainers and the whales that has provided for reduction in safety mishaps at SeaWorld. Yet it's that close contact that OSHA wants to end. SeaWorld continues to employ close contact procedures as part of its business model and safety mishap reduction efforts. It is just plain wrong to use SeaWorld's own voluntary safety procedures against it to show inherent dangerous evidence. SeaWorld reserves the right to alter its safety control measures as the mitigation conditions change. As for notice, OSHA is telling you that what safety measures SeaWorld is doing today is evidence of wrongdoing, and yet OSHA is trying to prosecute SeaWorld for implementing those very safety measures. This case should defer to the real field experts and the industry standards for recognizing inherent danger. Otherwise, we are left at the mercy of OSHA's daily warnings for prosecution. We contend that OSHA is not empowered under the terms of the general duty clause to change the inherent business model of an industry. Thank you.
Thank you for your testimony. We respectfully deny the petitioner's review.
All right.